So just a quick recap. I just got done attending the Leonard Pozner versus Halbig, what we think is to be the final hearing now. But today's hearing was Wolfgang Halbig basically filing a motion to tax costs. They claimed that they were the prevailing party after Pozner dropped the case, so they basically wanted to get the court costs and some of the other miscellaneous fees that Wolfgang incurred in order to defend himself waived or at least decreased. And the other motion was to recuse judge, which means that Pozner thinks that the judge is somehow in collusion with Wolfgang or is working with some sort of conflict of interest. And it seems that the judge was immediately swapped after that. I've been told also that he wrote a very long piece about why the judge, Briggs, could not understand why Pozner would make this claim. But that apparently stirred the pot enough to where they just replaced the judge anyway. So all we really heard today was the motion to tax costs. The judge denied at the end the motion, not really giving much of a reason. He did state that the actions taken weren't absolutely necessary, such as he could have emailed instead of mailed the documents to the other side, to the plaintiffs, but it really doesn't make a whole lot of sense when it comes to like the court fees and everything. You know, Wolfgang had to defend himself, he had to incur costs. The judge just didn't give much of a reason. So that's basically what happened today. It was just in a chambers room, as you'll see in the video. It was not in the courtroom, and Mr. Pozner and their paralegal Estupiñán from the Allen Marcus, I always get the names confused, from that law firm, they were not present today at all. Usually at least someone is present from the other side, but today no one showed up, and we just did a conference call in a chambers room, which was interesting. But really, at this point, I'm not surprised by anything that happens at this courthouse or with this case. But yeah, that's basically what happened today. Mr. Marcus Allen popped in on the phone call. We did not know that he was on the phone call. It didn't appear that he was. It seems to only be Patrick Estupiñán, but it seems that Mr. Marcus popped in and made himself heard when he wanted to object to something that Wolfgang's attorney had said. But once again, you'll also see that in the video. So I think that pretty much sums up today. I think Wolfgang still has some plans to take action in regards to this case, but we will see about that. Other than that, I hope you enjoyed the video. Sorry if the sound is a little low. It's always difficult to try to capture the audio in these rooms when they always put me in the back corner of the room and they don't talk very loud, and Mr. Patrick Estupiñán is over a conference call and doesn't speak, the best English, so it makes it difficult to understand what's going on in there. But if you have any questions, just feel free to ask. I'd be glad to answer because I was present. Other than that, that's about the sum up of today. Possibly the finale, who knows, of Leonard Pozner versus Wolfgang Halbig, which initially Mr. Pozner was suing Wolfgang because he posted his personal information online, which Wolfgang would argue that it was already public information and that there was really nothing but more of a frivolous lawsuit here, and that's it. So that's about it. Signing out. We are Change Orlando. This is Justin Harvey. Peace.
I'm Alan Key Marcus on behalf of the safety of Leonard Pozner.
All right.
I could not understand their names.
It's Patrick Estupiñán, Estupiñan. Did I get the spelling correctly there, counsel?
Yes.
All right, we've got defendant's motion to tax costs, is that correct?
Yes, Your Honor.
Okay. Go ahead.
Thank you, Your Honor. Go ahead, counsel.
Yes, I'm sorry. Do we have a court reporter in the courtroom?
Yes.
We're actually in chambers.
Can I have their information, please?
He's asking for your information.
From Kerr and Associates, Mary Samuel.
Okay, go ahead.
Thank you, Your Honor. We were previously here in front of Judge Briggs on November 7th, handling a plethora of matters, including some discovery issues. There was a court order issued in which the defendant was supposed to appear for deposition as well as produce overdue discovery. Instead of producing the discovery in accordance to the order, on November 13th, a notice of dismissal without prejudice was filed. We are here today seeking to recover the costs that have been incurred by my client, Mr. Halbig, attached to my motion to tax costs. There is about, well, let's get the exact number, $3,373.73 made up of mileage, court reporting costs, as well as the costs associated for transcripts, sending items via priority mail, etc. So what we're here to do today is ask you to declare my client, the defendant, Wolfgang Halbig, the prevailing party, and grant us entitlement to tax costs pursuant to Florida Statute 57.041, as well as, I believe it is 1.150. 1.525.
Yeah. All right, yes, sir, response?
Yes, Your Honor. First, the defendant is moving under Florida Statute 57.041. That statute is titled Cost Recovery from Losing Party, and specifically subsection 1 states the party recovering judgment shall recover all his or her legal costs and charges, which shall be included in the judgment. Subsection 2, costs may be collected by execution on the judgment or order of assessing costs. There's no judgment entered in this case. The plaintiff voluntarily dismissed without prejudice this action. And the second statute, which counsel just referred to, 1.525, is not even in their motion to tax costs. But nonetheless, if Your Honor is going to allow the defendant to travel under this statute, it is still accusation that the defendant is not entitled to any one of these costs. We can go one by one. So first, the letters that the defendant sent by certified mail, which is an amount of $90.58. First, these letters, they shouldn't have been sent certified mail. They could have been sent by email. The defendant has always had our email. There's no reason why he couldn't send them by email. There's no requirement under Florida law that he had to do so. The second one, the discovery documents sent via priority mail, an amount of $132.50. We've never even received any discovery documents from the defendant, which is why we had to move to compel discovery production. Notwithstanding, any such answer and responses that the defendant would have sent to us, again, could...
I'm sorry you were cut off somehow.
I was saying that for the discovery documents that allegedly were sent by the defendant through us, first, we never received any discovery documents, which is why we've moved to compel several times the production of documents by the defendant to us. The next item would be the printing of discovery documents, which is an amount of $626.37. Again, we never received any discovery documents, and to the extent that any such documents were produced, which is our position that none were produced, the defendant could still produce those documents, answers to interrogatories or request production responses via email. Now, we did take a look at the receipt that the defendant attached to his motion. And I would direct Your Honor to that receipt, even though the defendant claims that they were from Staples. They were actually from Office Max and Office Depot. And in there, even though it's by code, if we went online and we inserted the code for the item purchased, and it turns out that it was one, a USB flash drive for $499, two, a yellow printer toner for $348.99, and the other one was a printer toner for black ink for $130.99. The plaintiff does not pay, shouldn't be made to pay the defendant for these printer toners. Now, with respect to the hearing transcript, which is the next item that the defendant is claiming the cost for, the defendant never used any of these transcripts in this case, not in one of the defendant's motions. And it is our belief that the defendant only purchased the transcripts for purposes of continuing to harass our client, the plaintiff, by making these transcripts public. First travel time, an amount of $673.03. The defendant is not entitled to travel time. There's no rule cited in the defendant's motion that he's entitled to travel time, let alone the calculating the cost of 0.535 cents per mile. There's no case law cited in the defendant's motion. There's no rule. There's simply no basis for it.
All right. Yes, sir, response?
Yes, Your Honor, thank you. As to the position stated by counsel that we never produced discovery, that is incorrect. In fact, at the last hearing, we went through our discovery responses in open court, for which Judge Briggs granted the plaintiff's motion that we produced better responses. So there's no way he could have issued us to produce better responses if we hadn't already produced discovery responses. That's for one. As to what is taxable and what is not, I just recently sat through a luncheon with the Honorable Judge Kest in Orange County, in which we discussed that what are taxable costs. There's wide judicial discretion to make those determinations. Anything with a receipt is obviously going to help. When you have a pro se litigant like my client here, the judge is obviously allowed more discretion to grant such things like postage, whereas a larger, bigger firm, a judge may not grant postage in that circumstance. But for a pro se litigant, this is the type of situation where these would be taxable costs. Also, it needs to be made clear that we're not attempting to tax for travel time. This is not a motion for attorney's fees. We're only moving for costs. We are moving for mileage from my client's house to the courthouse and back, whether it be to file pleadings or to attend hearings. I just want to be clear, we're not moving for time, we're not moving for fees, we are moving strictly for costs. Also, I have a letter here. This is for settlement purposes only, but there is a number claimed where the plaintiff is attempting to make a settlement with my client here.
Objection, Your Honor. Your Honor, this is Mr. Marcus. I would extremely object to any discussions of settlement in the case. It's outside the scope of what should be brought before the court, and I don't know what counsel intends on stating after he starts out by saying that these were settlement discussions. So I would strictly request the court order counsel not to go into settlement discussions in his argument for costs.
All right, I'll sustain the objection.
Thank you, Your Honor. Again, all costs are, the judge, Your Honor, has wide discretion in determining what are taxable costs and what aren't. We have included a very detailed list of what we believe are our taxable costs. There were some items that were left off because I felt they were in a gray area. Everything that was attached to our motion, we believe we have a strong argument. Certainly, it's within Your Honor's discretion to determine them as costs. So again, I would ask that Your Honor grant our motion to tax costs in favor of the defendant here today.
Yes, sir, any other argument?
Again, this is Mr. Marcus. I would just say that they were not a prevailing party in the case. There's no case law that has been cited by the defendant's counsel stating how he intends to show or have this court determine his claim to be a prevailing party, which is required under the statute that he cites and travels under. And number two, none of these costs are reasonable. Paying for toner, certainly wouldn't expect anybody to pay for toner from my office to buy toner. You charge per copy for an item, I can specifically state, and Mr. Estupian was not involved in the entirety of the case, so there's a couple things I know that he does not know, so if I could just add to it. Number one is I know there was no discovery whatsoever. The only discovery responses by Mr. Halbig in the case were pleadings in response, formal responses to interrogatories and requests for production. The pleading itself, there was no discovery whatsoever. So for him to charge or attempt to charge $600 and some odd dollars for copy charges for discovery that was never produced, and counsel has not produced any documents to show copy charges. What they produced to date is invoices which we had to investigate ourselves. I mean, I don't think they were upfront with the court by indicating and couching them as copy costs when they were, in fact, procurement of items for a copy machine, toner, etc., and a flash drive. I don't know what Mr. Halbig's using with the flash drive or how many other copies he made for other matters with the toner he bought, but certainly we shouldn't have to pay, or my client shouldn't have to pay for toner and a flash drive that he may have used for other purposes and had plenty of it to copy for the next month, not alone in this case, and there's been no showing of any copies that were produced by counsel. Additionally, I've never heard of a defendant or a party that gets able to charge mileage for coming to court and going from court. Certainly we travel from Dade County as attorneys in the case, so and still I wouldn't, as an attorney, be entitled to mileage for those charges. And again, having been involved in the case from the inception, the transcripts that were purchased and the nature of this case was an attempt by my client to have Mr. Pozner Mr. Halbig desist from disseminating false, fraudulent, defamatory information to the public against my client. We attempted to succeed in that for purposes that I do not have to reveal. We decided to dismiss the case without prejudice, to seek other action, to maybe get a better result from in a different form. Let's say that, not forum shopping as far as circuit court or courts. I'm saying in a different forum because of the limitations of the court system to enact certain protections against a person from defamatory matters. I can tell you that the sole purpose of the transcripts, as we've seen, there was not one use of any of the transcripts, any of the pleadings, or any of the proceedings before the court, and that as soon as the transcripts were copied, they were put and published on various domains in the country for purposes of self-serving purposes of Mr. Halbig, and they were not used in the court proceedings. So my client shouldn't be taxed for Mr. Halbig's attempt to video, have TV reporters, and disseminate this information by way of transcripts also to the public. And I think that's it, Your Honor. And I appreciate your ability to let me put that on the record.
Thank you, Your Honor. Plaintiff elected to file an injunction against my client. As for all the other information that was just proffered by counsel, none of that was contained in the initial complaint. And the rules are clear. Like I said, Your Honor has wide discretion to determine what are taxable costs and what are not. My client litigated this case pro se at great expense in cost and time and money for a very long period of time. I believe this was filed in 2016. It may have been filed before. My involvement was didn't begin until 2017. You know, there are rules for these sort of situations. Plaintiff elected to dismiss the case, and for all intents and purposes, the defendant, Mr. Halbig, is the prevailing party here. So again, I would ask that Your Honor grants our motion to tax costs today. Thank you.
Anything else?
There's nothing other than there's no case law to support counsel's position that a dismissal without prejudice makes his client a prevailing party under the statute he's found.
All right, at this time, the court finds that the defendant has not proven that these costs were necessary in the action. Therefore, I'm going to deny the motion to tax costs at this time.
Thank you, Your Honor.
Thank you, Your Honor.
Yes, sir.
Your Honor, will you be submitting an order, or do we have to submit it?
If you would submit it and run it by opposing counsel for approval of the form.
We'll send it to him today.
Okay.
Thank you, Your Honor.
Thank you.
Appreciate your time.
Yes, sir.
Thank you.
Mhm.